lights in the background's crazy.
I couldn't hear you just now.
I said the lights in the background are crazy, Warlord. You know that, right?
Yeah, boy.
All right. I think this will be a pretty interesting one. We're going to go over felonies and misdemeanors, and then with whatever time's left over, we're going to go into felony or misdemeanor, and then a little statutory interpretation. So it's going to be good.
All right. Right now, it's just I think one other person is in here. So
Who?
we can shoot just a little bit if you want.
About what?
Whatever. While we're waiting for some folks. That wasn't here, but they do show.
So, how are you feeling knowing that Kamala has sealed the deal and she's going to get elected now? How do you feel about that?
What are you talking about? She ain't sealed the deal. She's not going to get elected, bro.
I hear the writing's on the wall, my man. I hear it's over.
They said at work, right?
I'm just saying. They said I heard my friends say we need a roll of backwood with Trump inside. That's what they said to me. They said they're smoking on that Trump pack. That's what my friends said.
Oh, you're being sarcastic. Oh, I was about to say, I don't know what you heard, bro, because no, everybody's like, no, he did not.
All right. Well, on a serious note, Amaya has been playing Quidditch Champions, and as a Harry Potter fan, it's making me sad.
She's not doing so good?
No, she's killing it, but I'm a Harry Potter fan, so like me, I want to play the game because I need to play. Okay. It just makes me sad.
So play.
I haven't caught a snitch, you know what I'm saying? She already caught like 7 of them. It's just I feel like I don't even feel like a real Harry Potter fan.
D Hill's up in here, but it says no one's viewing it.
Oh, my legs. All right, buddy. I'm excited. I'm not gonna lie. Huh?
So you ain't got no leg, bro.
You want to start?
I'm trying to see if I can see in the chat.
Hey, what up, D Hill?
Okay, so I guess it's just not showing us accurate numbers. That's all. We can start with D Hill. I said I guess just not showing us accurate numbers. It was good, D Hill.
All right. Well, first things first. I want to say, hey everyone, this is episode 2. I want to say first and foremost, thank you to Warlord. I know he doesn't have to do this. He's an awesome guy, and he knows deep down I just want to be a professor, so he doesn't care, and he's awesome for letting me get my teach on. I'm going to do the same rigmarole that I always do because I say it all the time. I got 3 kids and an old lady. I can't lose my license. I can't lose my job. So I got to go over the same thing. So everyone just work with me. First things first, we're talking about the concept generally of criminal law. So I want to say, again, I'm going to go from general to particular like I always do. Also, I am licensed to practice law in the Commonwealth of Virginia. What that means is I am not speaking as it concerns any other state or Commonwealth or any other sovereign area. It's just good old VA. I will talk general principles, and if you do feel inclined to look it up for your particular state or region or area, by all means, please do that. But I do want to reiterate, we're talking VA. And last but certainly, last but certainly not least, I am not in any way trying to give legal advice to anyone. Again, I like my job. I got 3 kids and a wife. I cannot lose that job. So top priority for me is I'm not trying to establish an attorney-client relationship with anyone. Warlord still owes me money, so I'm not doing that. But most importantly, I do this most importantly to educate. That's why I do it. I love to teach everyone the law. I think everyone should know the law. So that's kind of why I feel very passionate about this. So before we go any further, Mr. Warlord, yes, sir. Yes, you have a question.
Hey, I got a quick question. You're still breathing, right?
I am still breathing, yes.
So I don't know your goddamn thing.
Okay. Thank you for the interruption, Mr. Warlord. Last question. I see something in the comment. I'm gonna look at it real quick. Hey, what's up, brother? Good to see you, D Hill. So, all right, this is probably one of the biggest things that I really want to stress. People may think I'm being a little hyperbolic, but I don't think so. So, misdemeanor versus felony, right? I want to go into it now. We're going to dabble into it a little bit. Then we're going to go into statutory interpretation. Statutory interpretation is just a fancy way of saying how you read and understand the law, right? Long story short, when people say statutory interpretation, what they're saying is when you read this statute, when you read this law, what does it mean? How are we supposed to understand it? All right. That's what they ultimately try to mean. So, first things first, what is a felony? Now, a felony is a serious crime that's punishable by a term of imprisonment in a state or federal prison for at least 1 year or more and a possible fine. You're going to see that year mark is usually the threshold, right? More than a year felony, less than a year misdemeanor. So, general rules that more than a year felony, less than a year misdemeanor. Or, right? Now, in Virginia, we have the big statute. Again, if I was in my classroom, I would bang on the desk, stomp my feet, say, this is what you need to know. Because this right here, ladies and gentlemen, is what you need to know. All people. 18.2-10. That is punishment for conviction of felony penalty. That means they're going to go over every single thing. They're going to go over felony 1 all the way to felony 6. So in Virginia, here it is. It's this. And I'm going to go in reverse order because I like to go from least severe to most severe. Class 6 felony. You're going to get a term of imprisonment of not less than 1 year nor more than 5, or in the discretion of the judge or the court trying the case without a jury, confinement in jail for not more than 12 months, and a fine of not more than $2,500, either or. So let's break that down. Class 6 felonies, 1 to 5, off the rip, 1 to 5. That's a lot. Now, people get a little confused on this next part, but if you just break it down, it's not that crazy. A term of imprisonment of not less than 1 year, nor more than 5, or in the discretion of the jury or the court trying the case without the jury. That's just a fancy way of saying a bench trial. So there's jury trials and bench trials, right? Jury trial means you're going to present all this evidence to the jury, and they're going to decide. And the judge is there mainly to make sure that, attorneys aren't going at each other, getting all slimy with it, right? But that's a jury trial. Bench trial, no jury. It's just judge, attorney, and attorney. That's it. And honestly, I'm a fan of that one. That one's for me to, hey, it's just you. It's just me and you. And all we're doing is arguing law, essentially. So now, confinement in jail for not more than 12 months and a fine of not more than $2,500. So remember, in Virginia, you're going to see this a lot. There's usually a fine. They always come for the pockets in VA. They always come with some type of fine in addition to, right? It's not required or both. Either or both is usually the terminology. It's not usually required, but more likely than not, Virginia's going to hit your pockets. Now, that's class 6 felony. The next one, you're going to see jumps. I'm going to be real with everyone. You're going to see jumps. Class 5, a term of imprisonment of not less than 1 year, nor more than 10. Or in the discretion of the jury or the court trying the case without a jury. So again, jury versus bench trial. Confinement in jail for not more than 12 months and a fine of not more than $2,500, either or. So now we go from 1 to 5, felony 6, to 1 to 10, felony 5. Again, that's doubling. We're doubling now. It gets big, but the fine still remains up to $2,500, either or, which means the judge could hit you with both, or the jury could hit you with both, right? So, baby stepping. Class 6 felony, 1 to 5. Class 5 felony, 1 to 10. Now, this is the jump. And Warlord's going to probably hear and be like, wow, that's not as bad. But then class 3 is where it gets a little weird. Class 4, a term of imprisonment of not less. What's up?
Huh?
Oh, I said class 4, a term of imprisonment of not less than 2 years, nor more than 10. So what's the difference between 5 and 4? Hey, it's the bottom now. Now they could double you out. Now it's 2 years at minimum, off the rip. So not less than 2 years, no more than 10, and subject to subdivision G, a fine of not more than $100,000. That's class 4. That's just a class 4. It's class 4. So that's the most they can give for class 4. That fine is, again, if you think about it, class 5 and 6, the fines are what? But again, the minimums are 1 to 5 and 1 to 10. Class 4 is where it jumps. Class 4, 2 to 10 and 100K. I ain't got no felonies nor misdeeds, hey Hammy, but how much for your services just in case I gotta rough somebody up out in these streets? Hey, I'll be the first one to say it. I'll be the first one to say it. I don't have my own practice. I am a criminal defense attorney. I do public defense work because I really want to help those who can't really afford it ultimately. And don't get me wrong, I maybe one day, but truth be told, my secret, and I'm straying. We're gonna get to felony 3, but I think I want to be a judge. I think I want to be a judge, or maybe have my own firm. But I deep down, I think it's either the bench or become a professor. But enough of that. But hey, we got to learn the law before we can, practice it and judge, right? So hey, all right, warlord, class 3 felonies, a term of imprisonment of not less than 5 nor more than 20. And we're at class 3. Class 3 already gets you 5 to 5. Oh my gosh, 5 to 20. Subject to subdivision G, which I'm gonna read it briefly. But again, felony 3 also has that 100K fine amount. All right, so these are the tough ones where if you see these, this is real. Class 2 felony, 20 to life. 20 to life. Imprisonment for life or for any term not less than 20 years. Not less than 20 years. And subject to subdivision G, which we're going to read, a fine of not more than $100,000. I mean, if I'm going to be brutally honest, I've dealt with many class 6, class 5, and even a couple class 4s. Class 3 or 2s, that's real. Like that's serious. And you guys already know what class 1 is, right? Class 1, life. That's just straight up. Life, a fine of not more than 100K. However, there's a little caveat. It's wild, warlord, bro. I'm not gonna lie. As I was reading this and preparing it, I was thinking to myself, woof, like straight up. Hey, class 1, it's a wrap. Now, there's an interesting little subsection. I don't know if you guys see it. Again, I'll say the statute code 18.2-110. If you read A, it says any person who is 18 years of age or older at the time of the offense and who is sentenced to imprisonment for life upon a conviction of a class 1 felony shall not be eligible for parole, any good conduct allowance, or any earned sentence credits under Chapter 6, which is another subsection, or conditional release. I hope everyone heard that. If you're 18 or older and you get hit with a felony 1, it's LWOP, not just life without the possibility of parole. It says it right there in the statute, shall not be eligible for parole off the rip. So I say that sincerely as a way of saying, this is why I really want people to know the law, right? And this is not, I'm giving commentary on anything. This is just my way of saying people, when they're young, they don't think about stuff. Like I mean, we've all done it. We were all, and thankfully I was in, the Marine Corps when I was being dumb and going out there and partying being stupid. But like, again, all it takes is one careless action and you're looking at that. And if you're over the age of 18, it's over. Like straight up by statute. So heads up, right? So we went over that statute. There's a little bit more information in the statute. I highly recommend everyone to read it just because in my mind, I'm a firm believer you need to know the law, man. And let's be real. We joke all the time, but like you need to know. Again? Say again?
What's that statute again?
Yes, sir. So 18.2-10. That's the punishment for felonies. So again, everyone and know what happens when you get convicted of a felony. You lose rights, you lose privileges, you lose potential state benefits, you lose a lot. Like I want to be serious with everyone. Like I love this because this is such a real field of law. You deal with this every single day. I mean, Warlord and I went to a particular establishment when we were getting those interviews, and we were talking about things. And I thought to myself, and we were talking about like, hey, All it takes is one careless mistake when someone's doing something, and that's a charge, you know? So, all right, felony, right? More than 1 year. Or more, right? Now, misdemeanors. I've dabbled in all of these. I've dealt with them. I know these like the back of my hand, right? A misdemeanor is a lesser crime punishable by a local jail time of not more than 1 year and or a possible fine. Some acts may either be a misdemeanor or a felony depending on the circumstances surrounding the crime and the degree of the criminal act. What does that mean? I'll give you guys an easy example. Petty larceny in general, right? Larceny is just the umbrella term for the actual act of taking the possessions or belongings of another. Now, grand larceny versus petty larceny is as simple as what was the value? How much, right? Because in Virginia, over a K, you go away. That's what I say. That's a terrible saying. Over a K, I'm sorry. Over a K, you go away. Why? Because if it's over 1,000, it's a felony. And if it's under 1,000, it's a misdemeanor. It's a joke, and it's a terrible joke, and I do apologize. I'm not trying to make light of it, but just that's the way that you got to remember. You got to create little waves, all right? Over a K, go away. Now, I'm sorry, poor Lord. Another one. Hey, knock, ding dong. Hey, say again?
I said, you're the teacher, bro. I'm just here.
So, 18.2-10 is punishment for felonies. Now, 18.2-11, punishment for misdemeanors, right? Now, misdemeanor 1, not more than 12 months and a fine of $2,500. Not too crazy, right? Not too crazy. Misdemeanor 2, a confinement of not more than 6 months and a fine of not more than $1,000, or both, either or, right? Class 3, $500 fine or less. Class 4, $250 or less. Not too crazy. Not too crazy. Now, Warlord?
Yes.
You already know because I've sent you all these. So, I don't know who's here. I don't know who's watching. D Hill, since you're rocking with me, D Hill, I'm asking you all these questions. These are for you, D. Now, misdemeanors. We're playing misdemeanor or felony. So, D Hill, put your thinking cap on. I'm going to ask you, hey, I'm going to say a crime. You tell me what you think the punishment is for that crime. Felony or a misdemeanor, all right? I hope you're rocking with me, man. I hope you are. Now, D Hill, trespass, going onto the property of another without their permission or approval, right? Felony or misdemeanor? I'm gonna wait. All right. I want D Hill to, what's up, dog? Let me know. It's felony or misdemeanor. What do you think, Warlord? What do you think? Before have you actually looked at it and read it, or have you just?
I read what you sent me.
Okay. What do you think should be the punishment for a trespass? If someone comes to your property, if I come on to Warlord's property, say, hey, you know what? Nice yard, youngin', I'm running this.
Well, if it's my property, if they live, a misdemeanor the first time.
Oh, the first time. Interesting. Well, you're correct, Warlord. So the statute, everyone, is 18.2-119. That is a misdemeanor. But misdemeanor 1, which means you could get up to 1 year, $2,500 fine, or both. So it's nothing to laugh at. Now, Warlord, assault and battery, misdemeanor or felony?
If it's me doing the assaulting and battery, it should be a slap on the wrist. Anybody else, it should be a felony.
A felony. Well, 18.2-57 says an assault and battery is a misdemeanor 1. Misdemeanor 1 means you could get up to 12 months or a $2,500 fine. Now, I got to talk about something. In Virginia, misdemeanor time is halved. So, Warlord, yes, hey, D Hill, you're right.
Why is that?
Warlord, yeah. No. So, you guys, it's interesting, right? So, in Virginia, if you get found guilty of an offense, and you get 12 months straight, in actuality, you have to do 6
I'm sharing your live to everybody, by the way. Sorry.
What'd you say?
I said I'm sharing your live to everybody, by the way. Sorry. I'm paying attention. I'm just
No, you're good, man. No,
sharing.
you're good. So in Virginia, that's the rule. In Virginia, the rule is if you get an active sentence in Virginia, if it's a misdemeanor, that time's cut in half. So if you really want to get real, really in Virginia, a class 1 misdemeanor is not more than 6 months. If you get sentenced to the max, because it gets halved, which means a class 2 misdemeanor is 3 months, and so on and so forth. So it was a statute that was passed early on, Warlord. So there's an article that I'll send you, but ultimately it boils down to they earn like in Virginia, we allow for people to earn good conduct credit, right? And it results in their time. It results in the value of their time being doubled, but in actuality, them only having to serve half. So it's for misdemeanors mainly, right? So now I'm actually excited for this next one. Warlord.
Yes, sir.
Assault and battery on a law enforcement officer. Misdemeanor or felony?
Pretty sure they make it a felony. No, misdemeanor. Yeah.
Oh! It was a felony. You were right the first time. You were right the first time. So it is a class 6 felony, which means it gets what? Class 6 felony gets 1 to 5.
Okay.
Which is wild. And all right, so story time. I can't give you details, obviously, but I remember a client who had a pretty crazy record. Crazy record, not gonna lie. And he got into a little, situation. FTP. Yeah. I was confused. Yo, D-Hill's wild. I was confused for a second. I'm like, FTP, what is he talking about? And then I remembered. So this story, D-Hill's gonna make you think some kind of way. Now, again, I can't give you details. I can't tell you when this happened. What I can tell you is I remember I had a client once that had a crazy history and was being arrested for trying to barge in on his significant other's apartment. And cops get there and he tries to scurry off a little bit, right? They chase him down, he lays down. And he's getting loud and belligerent and all that. And they put the handcuffs on him. And he's complaining about his shoes. He's like, my shoes hurt. And the cops, they go, well, take off your shoes then. And he takes one off, and the officer says, hey, take off your other shoe. And the guy looks at his foot, looks at the officer that's to his right, looks at his foot again, shakes it, and just whack, and kicks the shoe off, hits the officer right in the chest, right? The officers look around, chuckle a little bit. They go, that is assault and battery on a law enforcement officer. That's a felony. And they chuckle a little bit, and the guy's like, I was just joking. They're like, no, that's a felony, bud. And he was charged with felony for kicking a sandal at an officer's chest, a flak vest that's made to, catch bullets. Did 0 damage to him, hurt his pride more than anything. He is facing a felony 5, which means 1 to 10, Warlord, for kicking a sandal at a law enforcement officer. So, the more you know. And long story short,
it's not a panel one, Sonny. It's not a panel. At the end, it's a panel, though.
Oh, actually, you know what? Oh, it would have been interesting. Because I would have loved to ask questions.
It's your class.
Well, let me go over these. We'll talk a little bit about the statute, and if we have 5 or 10 minutes, I do want to have a panel just because I wanted people to ask some questions about certain things. Now, JP's here. Good to see you. All right, so Warlord, assault and battery on a family member.
Former police officer JP as well.
Oh, I forgot JP Dougie was the officer. She's the ops. Huh? I'm
I said
joking.
he
She's
said
not
buggy.
stopped.
Oh, you
Assault and battery on family. So, Warlord, if Mrs. Hamilton decides she's sick and tired of me and gives me that,
the
that
flip flops?
that backhand, what do you think she's gonna get for it? Nothing, because she has a bunch of
Nothing.
friends that are family law attorneys and she knows a bunch of cops. But assault and battery on family member, what do you think it is? This misdemeanor or felony?
Probably a misdemeanor. Am I
That's
wrong?
right. No, you're
Mm.
not. Now, Warlord,
I mean, because it
let me
happens
ask
all the
you
time.
this.
They fight all the time, and then they go back to each other.
Well, I wish JP that they would get tossed, because in where I'm from or where I'm at, they definitely don't. It is a game, D Hill. It's a game. Which, hey, D Hill, this is yours. All right, Warlord. Everyone, check it out. Warlord said, and he's right, that an assault and battery on a family member is a misdemeanor. What if it's a second assault and battery? Is it a misdemeanor or a felony, Warlord?
Felony?
No, it's still a misdemeanor.
Okay.
Now, what about if it's a third within 20 years? What do you think? Misdemeanor or felony?
I would hope a felony by then.
Exactly. And they're Warlord's right, but that's the interesting part about Virginia, and I think a lot of states in general. You guys, it stacks. There are certain charges where they do stack, and I think that's a big reason why people really got to start reading that fine print, man. They really got to start reading those laws, because, again, I understand and it makes sense. Like, yeah, sometimes it's who wants to do that, and I honestly, D-Hill, I want it to be a game. I'm not gonna lie to you, but yes. So everyone, to recap. 18.2-572, assault and battery against a family member. It says if you're guilty of this within 20 years, three occurrences within 20 years, that's a felony, class 6 felony, which means 1 to 5, right? 1 to 5 is wild, but 1 to 5. Now, what is a family member? Do you think that that's defined? Yes, it is. I'm not even going to waste your time. It is defined, and it's defined in the statute, which is, again, another reason why people got to start digging into this stuff, man. It's wild. Now, we did that. I kind of gave Warlord a kind of like a layup on this one. Let him slam it down. Petty larceny, Warlord, is that a misdemeanor or felony?
Misdemeanor.
Yep. Yeah. And why are we already said that, right? Because the amount is the big issue
Because
when
it's
it
not
comes
over
to larceny.
1,000.
Over, my
Right.
man. If it's over a K, you get put away, right? That's the saying that I said. It's true. If it's over a K, you get put away. So it becomes a felony. Now, for the interesting one, I'm going to rotate this a little bit because I feel like, yeah, perfect. All right. Now, Warlord, possession of a Schedule 1 or 2 controlled substance. Is that a felony or a misdemeanor?
Of a 1 or 2 control misdemeanor.
Possession of a Schedule 1 or 2 controlled substance. 1 second. We got a crying baby.
It's not. This isn't
She
a
walked
panel
into the. She walked
not a
into
panel
the.
until the end.
What do you think, Warlord?
Nowadays, it's a misdemeanor.
Felony.
Oh, we was all
Nah, baked
wrong.
potato. It's a felony. So one
Deals
second,
for
I'm gonna let her
felony.
chill out. It's a D Hill. My guy D Hill, bro. You have a future family. You gotta go. You gotta come to us, man. Go to law school, because D Hill's on it. Now, she walked away, but yes, possession of a Schedule 1 or 2 controlled substance is a Class 5 felony. Now, Warlord, Class 5, is that 1 to 5 or 1 to 10?
Class 5?
Class 5, 1 to 5, 1 to 10.
Well, 1 to 6 is 5 to or 1 to 5. So I guess it's 1 to 10.
Warlord, yes, sir. That's it. It's 1 to
Yeah,
10.
boy.
Which
Give me more
is
money if I get
wild, sir. Wild, sir. But all right, now let's see, Warlord. JP said, "What is considered?" Oh my gosh, DV. Does it have to be actual action or perceived action? All right. Okay. We're going down this road. It is 1 to 10. Yes, it is 1 to 10. Felony 5. So weed is a Schedule 1. You know what? Actually, JP,
depends on the state.
Yep, I was about to say. So in Virginia, the approach by the Commonwealth is they do not pursue possessions of marijuana. So it is not a they don't classify it as a Schedule 1 or 2 here. So if you're in possession of it, they don't hit you with that. But we're going to go into a few of those because we're almost done with our misdemeanor felony game. And if you guys do like it, I think we should, if everyone's open to it, I would be down to make this a game. And I think it would be cool if Warlord was open to it, maybe something like if the winner either and we can give the winner a gift, something. Huh?
The winner gets a gift pistol whipping.
Why? No, we could give them hey, that
I'm playing my role for this class, bro. I'm playing my role for this class. I even got I couldn't on top of my grill, so I got the bottom.
Well, I was gonna say we can make your T-shirt with your logo on the back, and then Warlord McNasty, and then that could be like the first shirt that we give away. It's the person who gets the most correct. I thought that'd be pretty cool.
I can't do T-shirts until I finish Sonny's T-shirts. That'll be kind of messed up. She'd be like, "Yeah, I see how you doing," and I'd be like, "Sonny, I don't know what you're talking about, bro. Leave me alone." Like that.
All right, last question. Then I'm gonna answer JP's.
Oh yeah,
Possession of Schedule 3. Is that a misdemeanor or felony, Warlord?
Schedule 3. I don't know. Felony.
Misdemeanor.
Because we skipped 2.
Misdemeanor.
Oh, okay.
Right? Now, no. We didn't skip 2. No. So, see, the statute's crazy. So, possession of Schedule 1, 2. How it is written in red is 1 and 2 are encompassed together, and they are all a felony 5, which is 1 to 10. Right? That's what it is. And also, if you guys want to check, you guys can have fun with this. 18.2-250 is the statute or the code law for possession of a controlled substance. So I think you guys just check it out. And again, I love this. I wholeheartedly do. I think that this is probably one of the most important things to do. I think you guys should, again, know the law. Know the law because it's one of the most important things. I think there's 2 fields of law, and I say this as a joke to all my friends and they roll their eyes. I think there's 2 fields of law that shouldn't be just things that you need to know. No, you should know these 2 fields of law. They should be taught in high school. Crim law and wills. People are like, I get crim law, but why wills? And in my mind, wills is because everyone dies. We all die one day. Like we all go, which means your stuff is going to go somewhere, and you need to understand the rules where you live, so you know, hey, if I die intestate, Google that. I want to see who could figure out what intestate means. If you die intestate, what happens to your property?
What's that mean? So does that mean where you're like,
Google it? I'm not going to tell you. You got Google it. I'm not going to tell you. I am not going to tell you what intestate means. All I'm going to say is intestate versus testate. I wanted someone to figure out what that means. But we're going to keep moving on. Now, when we stopped last class, oh my God, I feel old saying that. But when we stopped doing this earlier, right? We stopped at a particular point. What that point was, it was an interpretation. Intestate. Let's see who can figure it out. Now,
does it mean auction?
Huh?
Does it mean auction?
No, it doesn't. I'm interested. You know what? Real quick check before I keep moving on. I want to see if anyone figured it out. JP with the Misty. Ew, that sounds gross. Okay, I was about to say, I was like, JP, Misty. All right, anyways, so statutory interpretation.
No,
so intestate. So
intestate.
When it comes to laws, they need to be interpreted a particular way, right? And now what that ultimately means is that they can't just be read so that they can be interpreted any way. We have strict rules for interpretation of law. Now, there is a general concept called written statute requirement, which is a fancy way of saying the criminal code must be written in a statute. What does that mean? Long story short, everyone, that just means that it can't be just on the minds of judges. It needs to be down, transcribed, so that everyone can see what they're responsible for. That everyone can see and know what they need to adhere to. That's the reason why the law needs to be written. Whoa, chill out, Amy. All right, sorry. Oh, mutual combat. Actually, all right. See, JP's got me distracted. All right, mutual combat is a defense for assault and battery, and it can work in Virginia sometimes. I've used it multiple times. It's judges are less inclined to allow that defense, and I'll give extra points to who can probably deduce why. Why do you think judges are less likely to let you play that card? Well, let's see who can sniff that out. But there's case law, Street v. statute, that essentially says that common law will operate, and I'm going to explain what common law is, but common law will rule unless the legislative has abrogated the common law into a statute. Individuals are presumed to, and this is the thing, you guys, the cases are already there. They're built kind of against us, if you want to be honest. Individuals are presumed to know common law crimes as well as statutory crimes. So let's break that down. Street v. State is a case that I really want you guys to look into. It pretty much says, hey, look, common law rules unless we have rules in place. Weird, right? There is a common law concept that we have. And what common law boils down to essentially is this notion that, and I guess you could deduce it or infer it as the blur of case precedent and common sense. So what common sense, obviously we know what it is, but case precedent is just the law or rules that are derived from past cases. So by combining these two concepts, what common law essentially means is, hey, look, we already know the law. We know it because we have common sense and we also have seen past rulings. These two blur together as common law. And what they say in Street v. State is ultimately that we're going to all adhere to common law unless we have a rule or a law explicitly in place for this. However, again, knock, knock, knock. However, everyone knows this. Again, individuals are presumed to know common law crimes as well as statutory crimes. This is why I'm a firm believer that you guys got to know this. You guys, like, I would love it if every class, every high school, every middle school had at least an hour a day on, like, hey, this is the laws of the land. You know what I'm saying? JP. Anyways. Now, retroactivity. This is another concept that I love because it's one of those that just, it shouldn't have to be explained, but it's kind of clear. You got a misdemeanor for assaulting an officer. In Virginia, what is that? In Virginia, that is assaulting law enforcement, assaulting LEO, and warlord, felony or misdemeanor?
Felony.
Felony 5 or 6?
5.
Warlord, what? See? Hell yeah. Hell yeah. That's right. Now, retroactivity, warlord, this, we already know what this is, right? This ultimately boils down to the idea of if there's a law or statute in place, you can't punish. Yes, warlord.
I gave them the answer. I told them to type it. They won't type it.
Yes, intestate if you die without a will. That is. Intestate if you have a will. So, yes, that's right.
Oh, oops, I'm sorry. Nope, someone did say it.
There it is. Hey, baked potato, I see you. Yeah, that's exactly what it is. Intestate die. Again, I'm going to be wholehearted. I'm going to be honest with you all. I love criminal law, but I can imagine practicing wills, trusts, and estates in the future. But I wholeheartedly love this. Now, retroactivity. Retroactivity, everyone, this is clear as day. If they create a law, they cannot now say that a law that is created September 12th of 2024 applies for acts that were committed in the past. And as a result, I can now charge you with a misdemeanor or a felony or what have you. So that's what it boils down to. Retroactivity is just another way of saying they cannot accuse you or charge you for a crime that happened before this was a rule or a law. Yeah. So right. Rogers v. Tennessee. And again, Every now and then, if you guys want, I can pass out this outline to everyone, or pass it to Warlord. And if he wants to divvy it out, you guys can totally.
I'll post
You
it
guys
on my
can
community
totally.
wall.
Yeah. We can totally do that. JP, there's too many words happening. Oh, stop! Come on. She's in politics. She knows words are all we use nowadays. Come on. We just big words, fuzzy words. That's all we do. Words. Now, I love this. Interpreting statutes in common law. Now, we have there's two camps actually. I love this class. I took a class, statutory interpretation, and people got into damn arguments over this. I am a fool. I'm sorry, D Hill. You're right. I'm just goofy. I love this, man. This is what I love. So look, statutory interpretation. You could be boiled down ultimately into two camps. There are the textualists and the spirit of the lawists. They're the purposivism, or ultimately what it boils down to is essentially, you have people who interpret the law word for word what the law says, and then you have individuals who interpret the law based on its purpose or what it was intended to do, right? And Warlord, off the top of the head, which one do you think is probably a little murkier? Which do you think? It's the purpose, man. And the only reason why I say that is because that easily can be massaged and modified. And I think the reason why I'm not a big fan of it is because you can bring in any factors at that point, right? If me and you were having a discussion and Warlord says, well, Mr. Hamilton, clearly the Second Amendment says in order to maintain a well-regulated, oh my gosh, a well-regulated militia, important for the maintaining preservation of the nation, the right to bear arms should not be infringed, right? Warlord says
Correct.
that, and Warlord says, Andre Hamilton, word for word, it says this. I can respond by saying, no. Unfortunately, Warlord, that law was created because it was trying to do this. And because this is no longer a worry or concern, this law can be modified now because it's not as applicable to the current times. And I hope everyone in the back is listening, because that sounds a little familiar, yeah? That sounds a little, and I'm being facetious, but ultimately what I'm saying is the two camps are here. You can see them now. Now that I've described them to you, you can see there are some that just what the law says is what the law says, and then there's some that say no. The purpose of the law is really what governs. Warlord, what's up, buddy?
One of your students would like to know when can she come up?
We're 43 minutes in. You know what? Yeah. Ha, JP. No, there isn't any manipulation of law. I will say one thing. We will talk about vagueness. I will talk about that one little point that JP brought up. And then, yes, if Baked Potato wants to come up, by all means, she can come up. So let's talk about, no, I will say JP is right about that. When it comes to the concept, right? I have a question about my rights. All right. When it comes to the concept of the purpose of the law, right? The big idea and notion that a lot of people allude to is, well, if I really want this goal, right? If I want this goal, I know now that I'm not going to be utilizing the text of the law. I need to figure out how to ultimately embrace this particular outcome of mine by addressing whatever purpose I deem is necessary to deem it obsolete. What I mean by that is, hypothetically, let's say I want to remove the right. Oh, I hate to use the Second Amendment because it gets spicy. Let's say, right? Let's say I'm going to do it anyways, just because for me it's the easiest one. Let's say I want to get rid of 2A, right? I'm done with it. Done with 2A. I say, well, look, I know that the strongest argument people have for it is the interpretation of it by word for word, right? So what do I need to say first? I need to say, well, you know what? That's wrong. That's an inappropriate interpretation because of X, and as a result of it, we need to focus more on the purpose, right? Ultimately, then, boom, I split the group, I split the camp. You're either going to work with the purpose, or you're going to say that the interpretation word for word textualist is correct. That's fine. Now, I'm not going to have to manipulate anything. All I need to do is look and take into consideration multiple factors that were mentioned, allude to, or referred to that were around the point when that law was made up. Excuse me, not made up, when it was.
Text history and tradition.
Yeah. Yes, but you want to ultimately refer or embrace concepts or concerns or worries that were emphasized during its creation or construction, right? So I don't. A lot of attorneys have the notion of like the Supreme Court is very, very. It's a function of its entire goal, right? Ultimately, if you want to argue a point, there's so much law that all you have to do is find a line of reasoning through whatever case precedent works for you, and you could get to your ultimate outcome. That's what I think JP is really pushing. She's really pushing, look, if you want this outcome, all you need to do is find the cases that get you there. Right? That's ultimately what it boils down to in law most of the time. If you think this is correct, then you really are going to spend a lot of time trying to find the cases that establish the reasoning to get to point B. That's what it boils down to. Now, baked potato. She wanted to come up, right?
Yep.
Okay, let's go. I think I'm ready. I'm ready.
HP said.
What were you trying to say, JP?
Oh, no, that's you, Andre Hamilton. You missed the point of what I was trying to say.
What were you trying to say, JP? Why does she come up here anyways? It's JP. What's she ducking for?
Well, because I only posted the link once for you since it's your thing. Oh. So you said you want to come in.
Yeah, we'll try to. I just asked Warlord that you.
I reposted it.
Yeah, you keep it. So I can respond. All I ask is you keep it ready so that if I want to try to say something, I can say something. Okay. Yeah, tell JP to quit ducking.
JP, Hamilton said, quit being scared. Right on his block. If you're really hard like that.
Roll a backwood. Put JP inside. Hello.
Hello. Oh, I was late to class. I really, I was going to wait to ask my question.
No, by all means. What's the question?
Oh, I can't ask here.
Okay. All right. Well, one, I appreciate you being here. Two, what is it?
JP said you got the concept of what she was saying at the end.
She's just ducking, bro. That's what that boils down to. She ducking.
He said, you're ducking real questions, JP.
All right. We're going to talk about two things real quick before I take a break and I talk to is this baked potato? I apologize. I don't want to use people's usernames. I feel like it's weird. I'm sorry.
Sunny baked potatoes.
Look at that. Oh.
Listen, if
what's
you
up? What's up?
So no, you got the concept in the end, but what I was saying, it was kind of it was a slight. When I'm like, it depends on how you articulate, because ultimately what you're doing when you're articulating a certain way, when you're using the spirit of the law and that interpretation, you are kind of manipulating. You are, in a sense, so it's a dance and it's an art form and it's beautiful and it's a gift when you can play both sides and you can use both and you're gifted at using both the spirit and the letter of the law. That's all.
I would agree. I would only push back, and I would also say that isn't a quality or attribute that is unique only to those who try to emphasize the purpose of law. I would also say textualists to a certain degree are also, I don't want to say manipulative, but are agenda oriented. So they may, and again, because you could push back and say, hey, well, and I've heard this many times, well, textualists, words meant something different back then. Or the grammatical structure of sentences cause for the meaning to be different. Like you hear all these approaches that allow for a different interpretation. So I would just push back, JP, and say that that weakness is prevalent in whichever camp you want to roll with. They're gonna poke that weakness all day long. It's a little more prevalent with those who try to emphasize purpose. I'll give you that, but I would say that that's not unique to them.
No, I agree, but I think that when I say manipulate, I don't mean it in a negative context. When you're articulating exactly how you want something to go, you favor that side of things, right? You're not going to necessarily bring out the background of the opposite of what you're going for. Like you're going to bring out what favors your argument. So you're going to, and I say manipulate because you're not going to bring out the full context of what's in front of you on all sides, all views of it. You're going to bring out the context of what favors your argument.
So, yes, now there are professional rules of responsibility for attorneys that require us to do just that. There's candor to the court, which essentially requires for attorneys, if we are making an argument, if we are aware or become aware of a weakness in our argument or case law that causes for our argument to be inaccurate at a certain point, we do have to bring that to the attention of the court. For example, Warlord is being charged with X. I have my argument ready and prepared, and brand new intern who says, "Hey, Mr. Hamilton, I just found this case law that says, this no longer is authoritative, and this is bad law." I can't just push that to the side and keep arguing because it's going to undermine my argument. I make my argument and then I say, however, Your Honor, at the end of it, I have just become aware that there is new case law that would very much weaken the authoritative demand or the authoritative force of this argument, and I keep it moving. So
you bring that up, moving. You don't find other avenues to go. You don't find a different argument to build on and make. Like you continue with that argument knowing that it's weakened. You don't formulate a different argument.
Well, in the particular scenario that I gave you, I became aware of the weakness in court, right? In the courtroom.
Oh, okay.
If hypothetically we had 2 or 3 days and I found out because, Mrs. Hamilton said, "Hey, Ivan, the intern, just told me that, our case law is bunk and, we need to find something new." Of course, you got time. But if, I'm walking in sipping Starbucks and Mrs. Hamilton says, "Hey, I just got a text from the intern, we're smoked. You got to get a new argument going." You can't. You make the argument that's prepared. Then you bring up the new case law that, causes, that weakens your argument. But what's up, ma'am?
And that I get that. I have to go. But quickly before I do, over there in Virginia, you never answer my DV question. Does it have to be actions or perceived actions?
So, God, I hate this answer. I always thought that this was a joke whenever I got this answer from attorneys. And ultimately what they would say is this very universally famous answer of "it depends." So when it comes mainly to assault and battery, by definition, assault does not necessitate harmful and offensive contact with another. It could also be perceived.
Yep.
Yeah, again, but Warlord, DV could also encompass assault. And if I am observed, or if a particular complaining witness observes my act and is harmed by it or offended, by that, I don't necessarily have to make contact to be found guilty of that crime. So in Virginia,
I have another question. So the way the law is written, it also includes perceived action. So if somebody scares their family member 3 times in a 20-year time frame, they're going to prison for a felony?
Well, all right. So one, is that family member bringing out the charges, right? If they are, they then need to be brought to court, subpoenaed, and they need to testify.
Yes,
right? And if they actually testify and explain to, judge whoever, my family member booed me and scared me, the judge will use their judicial discretion to make the determination of is this an appropriate
You're going
charge for the particular.
When I said I had to go, I asked if a person was convicted of DV for scaring a family member 3 times in a 20-year span, they're going to prison for a felony.
Okay, if you want the short answer, statutorily speaking, JP, yes. The answer is yes, because three misdemeanors within 20 years would constitute a felony. On the third offense, you'd be convicted, and it would be a felony 6, felony 5, I want to say.
I got a question after this, too.
Okay, I got to go, but it's been fun.
Felony 6. Felony 6, so that'd be 1 to 5.
Bye.
Thanks, JP. I got a question.
What is it, Warlord?
If you can answer this, so
I answer everything.
How much?
Sorry.
How much and how close in my personal bubble does somebody have to be for me to be able to say self-defense?
So, if you wanted to use the defense,
basically, how much of it is like assault on bearing?
I would say, again, the famous, and again, this is not legal advice in any stretch or scope of the imagination. This is a hypothetical between two friends. I would say it is fact dependent. The reason why I would say it's fact dependent is because ultimately, a reasonable and prudent person is going to be how the judge views your actions. They're going to say, well, would a reasonable and prudent person in Warlord situation be fearful that harmful or offensive contact would occur? If Warlord and I were walking and a small person bumps into you, would you be justified in just cold smoking? Are you saying you? What is she saying? I farted. Okay, thank you. Go on now. That's so ridiculous. Cute. Go. Yeah. All right. Go on. Go. You got to go. Thank you. So, Warlord, to answer your question explicitly, I would say it's very fact dependent. We're going to need to make a determination, and a judge is going to have to agree with that interpretation that a reasonable and prudent person would support the notion that you were in fear of harm to yourself or to others, and as a result of that, you then used appropriate force. It would be very much fact dependent.
Are you answering my question, or you're answering her question?
I answered yours.
Okay. So just really quick before she asks hers, I think you can say yes or no to this. And there has been cases where somebody didn't put hands on somebody, but they were justified in self-defense by somebody being in their bubble, right? Because they feared for their life.
Yeah. Well, again, I think that my response answers that for you entirely. If a reasonable and prudent person, based on the facts,
I had to really answer a phone call.
Warlord, the short answer is yes. A judge will make a determination. Okay. If they believe that the facts support the affirmative defense that you provided, then yes, you'd be fine. Even if they don't make harmful or offensive contact with you, you would have the right to self-defense.
Don't look at me crazy, or else I'm going to fear for my life. All right, that was it for me. She can ask her.
All right.
Thanks.
You're welcome.
Just because she had asked a question about if I think she said the argument is watered down or something like that. Or like she said something along that line. So I was going to ask you, what do you think about the YSL case?
So I don't know enough about the case. I do know that it's a RICO charge, and I know that RICO is a very, very sticky, very much, multiple webs have been woven, right? What I will say is, when it comes to cases such as those, I am confident that a lot of it is built upon, confidential informants or witness testimony. So again, without really digging too deep into the case, I really can't give you much besides that. Yes, ma'am.
So say if you do get a snitch, right?
Yes, ma'am.
That snitch flip. Like the snitch doesn't keep his word and snitch, and it just fucks up everything. Then what?
Well, all right. So if I was in that particular situation, if I was a defense attorney and my client, has someone who allegedly was a close member, affiliate, whatever, and then they flipped, I think by by definition of their position, they're impeachable off the rip, right? You have motive as to why you are testifying. You are been given a deal, and you would be bringing that up in cross examination. I'm very confident that the defense attorney there is bringing that up. Hey, you're getting a deal for testifying, right? You're going to do this. You're that. Like, you have reasons for testifying. Your motive is this, and I think that in and of itself will allow for a fact finder to perceive their testimony through a particular lens. So again, without being fully knowledgeable as it concerns the facts of the case, I would say that confidential informants or snitches generally are inherently impeachable, and their testimony is always kind of viewed as less than credible just because of their position they're in.
Right. Okay.
Warlord, you had any other questions?
Yes.
Well,
man, I did, but it's kind of long, and I think I might even ask you before. I don't know. So okay, so say you paid for like the top, the most expensive room or whatever, the most expensive penthouse at a hotel. Like, so say for like my situation or my instance, say excuse me, you're in a wheelchair, you're not using prosthetics, nothing like that, and they say, okay, you paid for our biggest package and all this other stuff, but the flip on the door, so we'll build a ramp for you, and it's not necessarily a part of like the contract, but it's like they give it to you in typing, email, all that stuff, and then they never build it for you. You don't have a good time while you're at the hotel, but you paid top dollar for that. Do you have a legal standing or not? But or they said we'll do all this stuff for you because you paid top dollar for our best room.
so I am this is a cool moment. So this is contract law, essentially, right? This is contract law. An offer was made to it is. An offer was made to Warlord. This offer said, hey, if you stay at our very, very expensive suite and pay for the price that we give you, that we've determined is appropriate for this suite, we will build this particular ramp that makes it accessible to you. Now, you accepted this offer, allegedly, and again, this is not legal advice. This is just us talking through a hypothetical. But That was an offer. You accepted it by payment, correct? Because you paid the necessary amount. Now, I would argue that you both received consideration. You got to stay at that hotel. They received the money and are keeping the money because of your stay. So I think you both entered into a contract. You guys are privy in contract, contractual parties, right? Now,
and ask for the ramp every night.
Yeah,
it was actually years ago, but still,
I would say, and again, my contract professor, I hope he's laughing if he ever watches this. I would say a material fact or a very important fact that was kind of presumed upon your entry into this contract would be that it would be accessible to you because of your particular situation. Now, the fact that they themselves affirmed this by saying, hey, we will make it accessible because it currently isn't. We will make it accessible by providing you additional, assistance, i.e. the ramp, if you pay and stay at this particular room. And I would say the fact that they didn't build that ramp is a breach in contract. I would then argue that you would or were financially burdened because you had to do additional acts, whatever, to actually utilize the room. So I'm inclined to say, based on the facts, and this is a hypothetical, I'm not giving legal advice, this is just a conversation between two friends, that yeah, I think that there was a breach in contract, and I think that there probably is something there. I would say.
And then now I think it was a scare tactic. And like I said, it was a cruise years ago before I was even comfortable using prosthetics. What they try to say in the email, and then they just didn't say nothing. So they're like, oh, but we're a French-owned company because somebody that's a lawyer or a attorney. He said, hey, I'm not writing this to you guys as his attorney. I'm writing this to you guys. Basically, it's somebody that knows what he's talking about, I guess he was saying. saying, we would like you to compensate him for him paying, $6,000-7,000 a night, and he didn't have a good time. And then they said, well, we're a French-owned company, and like that was it.
And what do you think they meant by that?
I think that they were trying to say, well, hopefully that you're dumb enough to think that you can't take us to court, even though we operate in your country as well, and they have American
they try to
offices.
talk about a few things. They try to say, one, we're not bound by your laws. Two, you don't have jurisdiction over us. Three, if you try to sue us, it would be improper venue because, again, you don't have personal or subject matter jurisdiction over us. And four, we don't even have enough contact with your country to try to bring us into court. They're wrong on a good chunk of those, right? Because I would say subject matter jurisdiction would be probably easy to prove because they're an international company that is coming to the United States for business. I would say the amount of controversy is well over the threshold. That'd be a fun. Honestly, you got me thinking, man. The next episode, I want to do misdemeanor and felony again because I think that's just fun. But at the same time, man, you got me thinking about other stuff. You got me thinking about other things and how charges are resolved in court. I'm a criminal attorney, so that's kind of out of my realm. But I think what I'll do, if everyone's okay with it, and again, I really hope people enjoy this. If they don't enjoy it, by all means, we don't have to do this anymore. But I do think that it'd be interesting to talk more about misdemeanors and felonies. I think it'd be very fun to, and I think that I hope I'm sensing this correctly. I do think that it would probably be in our best interest to pick one crime and just dig into that crime so that everyone has a good understanding on it. And then I also think that maybe 10 to 15 minutes at the end of each, we just have people to hop on, ask questions. We work our way through it. We ask they to be ideally referring to or concerning the particular topic that we addressed that day. But I think that'd be a good structure. We do a little bit of misdemeanor felony. We go over the big topic of that day, which will be, because I'm a criminal defense attorney, it'll be just one particular crime. We'll dig into it. And then we'll spend the last couple minutes talking about just, hey, what about this? Thanks, D Hill. I really do appreciate it, man. But I think, Warlord, that this would be an interesting interesting thing to continue on. I know we reached our hour. It's 8:00. Warlord, I'm gonna say the same thing I always say to you, man. I wholeheartedly appreciate this. I want to be a professor one day. I have to be a judge. So this truly forces me it forced me to do a lot of things. It forces for me to sharpen myself, to make sure I have a good grasp on the material. It allows for me to stretch my teaching muscles because, again, I do really want to do this in the future. And also, man, it gets, more time talking and hanging out with my friend, and I do always value that. So I do appreciate it.
So we appreciate you sharing the knowledge, just kind of, giving us some lessons, not as an attorney, but giving us some free lessons, man.
Hey, again, I love criminal law, man. It's fun, and I enjoy it. And before I hop off, hey, man, Carla Hunley. One second.
Okay. He said 1 second. Carla, he might be trying to pull up charges on you. Oh, okay. There you go. Guess y'all know each other.
Oh, thank you, Mrs. Hunley. Sorry, I'm a little. That took me a little bit.
You turning up, bro? Ain't nothing wrong with that.
Yeah. Sorry, it took me a little bit for a little bit. Sorry. Thank you, Mrs. Hunley.
That's what's up.
Wow. Sheesh. Sorry, that threw me for a little bit. D, I appreciate you, man. And again, I hope that that's ultimately the goal, Warlord. I think that'd be fun. I was gonna ask you if you had any plans we could stream together, but again, I'm sorry, that threw me. I did not expect that. But next week, I'm gonna talk to Warlord, and I'll figure out a topic, man. I feel like, and again, I don't want this to be any issue because I know the content may be something that I don't want you to become demonetized. So I was going to do A and B. I was going to do assault and battery.
I'm not monetized yet, bro. Talk about what you want.
Okay, so I think assault. If you're okay with that, I think assault and battery.
Out there. Yeah, get the scare stuff out there, or we're monetized. I mean, you'll know when I'm monetized because I'll be sending part of it to you. Like I said, like,
oh man, no, I don't.
That's just how it is.
Yeah. Thank you. Yeah, I think we'll do that. Oh gosh. Anyways, so thank you. She is my. Oh, that's embarrassing, bro. I did not expect that.
That's what's up.
But yeah, it's up to you, man. I'll definitely have it prepared and I'll shoot it over to you. But I want to say again, man, I really do appreciate it, and I'm looking forward to next week. I'm not gonna lie, it's fun. It's fun doing this, and yeah, man, let's keep in touch. Let's keep this going. Yeah.
Yes, sir. Definitely.
Take care, man.
Yep.
Later.
And thank everybody for joining us. If y'all think that we earn and deserve y'all like and subscribe, please give us a like and subscribe. We'd appreciate it. Thanks for coming in. Y'all have a good night. D Hill, Miss Carla, Loaded Baked Potato, aka Sunny, Josie, Mimi, Deanna, anybody else if I might have accidentally missed y'all, and whoever's in the bushes. Appreciate y'all. Y'all have a good night.